Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, our topic is your final report is terrible and you should not sign it. And I'm poking a little bit of fun and trying to create a little bit of humor about this very important topic, which is your final QME report and the impression that your report makes upon the reader of your report. So before we begin today's discussion, let's define and describe what it means when I say that your final report is terrible. And I'm not talking about anyone here in this audience or you specifically, but I'm rather referring to the community of qualified medical evaluators who collectively and as a group have a reputation of producing, on the whole, reports that are terrible and low quality reports. And this is not my conclusion. This is not something that I've come up with. Rather, this is the conclusion of no less an authority than the state auditor of the state of California, who recently conducted an audit of the Division of Workers' Compensation and found that the Qualified Medical Evaluator's report has some problems in it. And as a group, Qualified Medical Evaluators reports tend to fail to be able to resolve disputed issues for which the Qualified Medical Evaluator was initially hired to resolve. So the report, number one, does not resolve the issue for which the Qualified Medical Evaluator was hired to resolve. And then number two, by not resolving the disputed issue within the body of the report of the Qualified Medical Evaluator, that report introduces delays, unnecessary delays into the system and into the resolution of the case, and unnecessarily drives up the costs of the case. So with those characteristics or those factors taken into consideration, terrible reports are a terrible problem and a terrible burden upon the system. And the state auditor issued an edict to the Division of Workers' Compensation to immediately begin to improve the content and quality of Qualified Medical Evaluators reports such that those reports could better resolve disputed issues and could better expedite the resolution of claims and could better help to constrain and control costs within the workers' compensation system. So in today's discussion, I want to share with you some very simple tweaks that you can make to your next report to make your report infinitely and immeasurably better at actually resolving the disputed issue and thereby bringing these cases to a quicker resolution. And I want to begin today's discussion by sharing with you what are some of the important codes and regulations that describe the evaluation process and then also the construction of our QME final reports. So we'll begin with a discussion of the most important sections of Labor Code 4628, which describes and defines what qualifies as a medical legal expense and how our reports as qualified medical evaluators, how our QME reports qualify as a medical legal expense that commands a reimbursement, and what omissions from our QME reports make our reports not eligible or ineligible for actual reimbursement. We'll talk about how to construct the opinions and conclusions of your report consistent with 8 CCR 35.5 and also 41C5, which describes the ethical requirements. And these are somewhat overlapping codes and overlapping requirements for us as qualified medical evaluators. So we'll talk about those two regulations in tandem. We'll talk about what 8 CCR 9793 has to say about the components within your report that qualify it for reimbursement, and specifically, and I'll just share the punchline of CCR 9793 with you. In order to qualify as a reimbursable medical legal expense, your report must be capable of proving or disproving a disputed issue. And that language is almost exactly out of the verbiage of the language of 9793. If your report is not capable of either proving or disproving a disputed fact, if it doesn't resolve the dispute, then it doesn't have to, by law, be reimbursed by the claims payer. And I'm going to share with you some ideas to ensure how your report can actually, in every single instance, actually resolve the disputed issue. And it has to do with the discussion section of your report. And I'm going to share with you some ideas that you can immediately implement with your very next evaluation. We'll talk about 10682, California Code of Regulations, which describes the minimum standards, the minimum components that our report must contain, the minimum topics, the minimum headlines, the minimum categories, the minimum headings, the basic headings that our reports absolutely must contain by law, and this is the law, Regulation 10682. And the Division of Workers' Compensation is going to be looking at your reports more closely over the next weeks, months, and years as they attempt to ramp up to more tightly police Qualified Medical Evaluators reports. And this is where they're going to be looking. They're going to be looking to 10682 and comparing your report against 10682 to ensure that your report does indeed meet minimum reporting standards. And if your reporting does not meet minimum reporting standards, 10683 is a code of regulations specifically directed to the workers' compensation judges, who are now going to be given the added task on top of their already innumerable tasks that they complete down there at the workers' compensation courts. Judges are now going to be given the responsibility of identifying poor and low quality reports that fail to resolve disputed issues, and the judges themselves are going to be responsible for reporting to the Division of Workers' Compensation these faulty and low quality reports. And I can tell you, I was recently at an applicant attorney seminar where there was a judge on the panel, and the judge was talking exactly about this new language of 10683, and the judge was recruiting. The judge was recruiting both applicant attorneys and defense attorneys to help him, the judge, to identify those reports that are low quality reports, that are reports that don't resolve the disputed issues. So the judge, this particular judge, was distributing his workload and his burden amongst other parties to have other parties help him to identify these low quality reports, because these low quality reports don't simply trickle down and land on the judge's desk. What the judge is asking these other parties is the judge is asking them to help him to identify these low quality reports so that these reports can be identified early on, the qualified medical evaluator can be replaced, and the case can more expeditiously move toward a resolution. And then finally, in those cases where a qualified medical evaluator has had his reports rejected on at least five or more occasions, Labor Code 139.2 allows for a denial of the QME's reappointment for a new 2-year term. So there is established language within the law to help eliminate qualified medical evaluators from the system who just don't seem to have the capacity to write reports that are sufficient to resolve disputed issues in the system. So I've given these to you, and you should be familiar with each and every one of the entirety of the language of these codes, because being familiar with these codes and regulations can only result in one thing, and that is to help you write better, more complete, more thorough, and more by the book QME reports. So basically, these codes and regulations contain the instructions, the recipe, the formula for you to follow to help ensure that the product that you submit to the parties with your signature, which lives forever and ever out there in cyberland and represents you forever out there in cyberland and speaks for you and represents you, such that this product, the final product QME report, can be a report of which you can be extremely proud to bear your signature. So with that as our introduction, let's now go through some of the most important passages from each one of these codes and regulations. And I want to share with you some specific examples as to how these codes and regulations show up in the body of your QME report, and how when you pay specific and fastidious attention to including the details from each of these codes and each of these regulations, how that immeasurably enhances the perception of quality and the perception of your attention to detail as a competent and fastidious qualified medical evaluator. So with that as our introduction, let's begin today's discussion regarding your final report is terrible and you should not sign it. Okay, so let's begin at the beginning with Labor Code 4628. And 4628 is very, very interesting, and you should read the entirety of this code on your own when you get a moment, and take a look at your report and ensure that you have these components that are described in Labor Code 4628, that you already have them or that you get them installed within the body of your report. Now, as we begin Labor Code Section 4628, the first part of Labor Code 4628 is very, very important, and it has to do with the Division of Workers' Compensation's policy on ghostwriting. Ghostwriting is when another person writes the report for you. And ghostwriting, it seems, is a problem within the system, and the Division of Workers' Compensation is not keen on this idea of ghostwriting. The Division of Workers' Compensation wants to ensure that the final opinions and conclusions in every report are those of the evaluating physician, and thus the language of 4628 Section A. And let's read this together. It tells us that except as provided in Subdivision C, and we'll go over Subdivision C here in just a minute. Except as provided in Subdivision C, no person other than the physician who signs the medical legal report, except a nurse performing those functions routinely performed by a nurse, such as taking blood pressure, shall examine the injured employee. So no person other than the physician who signs the report shall examine the injured employee, or no person other than the physician who signs the report shall participate in the non-clerical production. What is the non-clerical production? The non-clerical production is everything but the clerical production. Clerical production would be printing, mailing, stamping, billing. That's clerical production, right? Transcription is clerical production. So the division wants all of the non-clerical, all of the conclusions, all of the content, all of the substance, all of the meat of the report to be that of the physician who signs the report. So they say, such as taking blood pressure, shall examine the injured employee or participate in the non-clerical production of the report, including all of the following. And let's read these. Number one, taking a complete history. So only the physician who signs the report should be the one taking the history. Now, there is an exception to this. Number two, no physician other than the physician who signs the report should be involved with reviewing and summarizing prior medical records, and there is an exception to this, but this is the basic principle. And then number three, no physician other than the physician who signs the medical legal report should be involved with composing and drafting the conclusions of the report. And this is the critical part. This is the anti-ghostwriting portion of Labor Code 4628, that no one besides the physician should be producing the opinions and conclusions of the report. So numbers 1 and number 2 have some exceptions, and I'll share those exceptions with you in just a moment. Number 3, there is no exception to this ghostwriting portion of Labor Code 4628. So if you are involved with using perhaps a consultant to help you troubleshoot some of the issues of the report and help you see and understand some of the issues of the report, It's okay to work with a consultant who can guide you in the proper direction for the resolution of your claim and your case, and to help you resolve the disputed issue of your evaluation. But the composing and drafting the conclusions and the language with which you describe your opinions and conclusions should be your own, and should look like your own, and the opinions and conclusions portion of your report should not look like it's been written by another person, because that would be a dead giveaway for a violation of this anti-ghostwriting statute. Okay? Now let's take a look at some of these other sections of Labor Code 4628. So we'll get to the exceptions that I just referred to, the exceptions that allow another person to obtain the history from the examinee, and the exception that allows other persons besides the physician who signs the report to do and be involved with the review of records. We'll get to that section of the code in just a moment. But in the meantime, Section B of Labor Code, Section 4628, describes some things that you want to ensure are within the body of your report to demonstrate to the parties that you know the codes and regulations and that you comply with these codes and regulations. So Section B tells us that the report shall disclose the date, when, and the location where the evaluation was performed. Now, as you know, the medical legal evaluation system is tightly driven by timelines. Every aspect of the medical legal evaluation, from scheduling of the appointment to the sending of medical records to giving the other party time to review the medical records to the time that we have to complete our medical legal report, all of that is governed by timelines. So the Division of Workers' Compensation is very sensitive to our compliance or lack of compliance to timelines. So that's the reason that they require evidence of the date of the evaluation, because the date of the evaluation must fall and must comply with established timelines. Similarly, the division is very sensitive to qualified medical evaluators moving examinees around to locations other than the location that's listed on the panel for which you, as the qualified medical evaluator, were either chosen by the unrepresented injured worker or were left as the last person standing in the case of a represented injured worker. Qualified medical evaluators are notorious for changing the location for the convenience of the qualified medical evaluator. And so the Division of Workers' Compensation is adamant that at least for the initial evaluation, that evaluation be conducted at the same address that the doctor was listed on the panel that was generated in the case. So I'll show you how these two requirements can be satisfied within the body of your report. The report should contain a statement that the physician who signs the report actually performed the evaluation. And this is what helps comply with Section A of 4628. The report must include a statement as to whether the evaluation performed and the time spent performing the evaluation was in compliance with timeline guidelines established by the administrative director. And I'll show you how to comply with that within the body of the report. And then finally, shall disclose the name and qualifications of each person who performed any services in connection with the report, including diagnostic studies other than its clerical preparation. And here, Labor Code 4628B starts to establish the exceptions that we talked about under Section A, such that if another party is involved with obtaining the history, if another party is involved with doing the review of records, you simply need to disclose. Disclose. You see that verb? The verb is to disclose, for you to confess, for you to admit, for you to give up the name and the qualifications of the person and give up what services, tell us what services those persons performed in connection with the report. Okay? And I'll show you how each of these can be incorporated within the body of your report. But let's just now look at Section C, which deals with those exceptions that we talked about under earlier section A. Okay, and then finally, the final section, section C of Labor Code 4628, gives us our instructions in those circumstances when we have other people involved in the preparation of the report. Now, I should tell you that having other people involved in the preparation of the report nowadays in the modern era is more the rule than the exception. It's very, very rare now that a single qualified medical evaluator does every single aspect of the evaluation and every single aspect of the report writing and submission process by him or herself. Many qualified medical evaluators are employed by management companies or use consultation services or use outside vendors and other parties that help them to reduce the burden of the workload involved with these evaluations, and that's okay. The Division of Workers' Compensation simply wants us to disclose who it was that performed services and what services in that report were performed by persons other than the physician signing the report. And if you use other persons, you can simply follow the formula established here in section C, and you will have no problem with your report being found to be in violation of this section 4628. So section C tells us if the initial outline of a patient's history, comma, or the excerpting of prior medical records is not done by the physician, right? And many physicians use a review of records company, a review of records service, and the physician gets a transcript of the review of records from the review of records service provider. So this is very, very common. The Division of Workers' Compensation recognizes this, and they just simply tell us that if this is the case, the physician still has some responsibility. He can't delegate this portion of the evaluation process completely and without oversight to another third-party provider. It tells us that the physician shall review the excerpts of the prior medical records, and the entire outline, which is the initial outline of a patient's history, and shall make additional inquiries and examinations as necessary and as appropriate to identify and determine the relevant medical issues. So if you have the review of records done for you by another party or another service provider, you're required to review that transcript of medical records and make additional inquiries to the examinee and make additional examinations and make additional investigations and whatever is necessary to determine the relevant issues in the case. You can't simply rely on the transcript of the review of records that's provided to you by a third party who has no vested interest or investment or obligation or has no obligation by law to the report. It's you as the physician that has obligation by law to the report, so it's your responsibility to review the excerpts, to review the entire outline, and make additional inquiries as necessary. So Labor Code 4628C, Section C, allows us to and gives us the exceptions to those components of the anti-ghostwriting statute related to the initial outline of the examinee's history and the review of records, but it provides for no exception to the third component of the anti-ghostwriting statute, which states that no person other than the physician who signs the report shall be involved with composing and drafting the opinions and conclusions of the report. And in this way, the Division of Workers' Compensation can ensure that the opinions and conclusions of the report are those and yours alone, are those of you as the Qualified Medical Evaluator and yours alone. And this is the anti-ghostwriting statute, which the Division of Workers' Compensation is very, very concerned about. And so make sure that if other parties are involved with you in the completion of your QME report, that the opinions and conclusions sections, which is the entire discussion section of your report, contains yours and yours only opinions and conclusions. Okay, so let me show you now how some of these requirements described in Labor Code 4628A, B, and C would look within the body of an actual QME report. And this will serve as a template for you as to how you can fashion some of these components into your own QME report. Okay, so here we are within the body of the report, and this is the introduction section of your report here. So this is how you can incorporate some of the components that are required by Labor Code 4628 within the body of your own report. And let me just tell you that incorporating these components of the law into your report demonstrates to the reader of your report that not only do you know the laws and regulations that govern the production of your QME report, not only do you know them, but you comply with them. And by demonstrating your compliance to the reader of your report, it impresses the reader of the report with your fastidious and meticulous attention to detail, which creates the further impression in the mind of the reader of your report that you know what you're talking about, that you know what you're doing, that you know the rules, the process, the regulations, and that you comply with the rules, codes, regulations, and the process. It's a very, very powerful procedure to demonstrate compliance with codes and regulations within the body of your report. So this is just some sample text, but it shows how to include the components of 4628 in your report. It says that Mrs. Jones was scheduled for an examination on such and such a date, and here you give us the date, and the division can later track this date and determine and conclude and confirm that you indeed are in compliance with all of the timelines associated with the evaluation. The evaluation was scheduled at 123 Main Street, Anytown, USA. So here you give us the location of the evaluation. And this is just some other sample text. Mrs. Jones identified, should say herself with a California driver's license. Also present during the evaluation was Maria Ortega, Spanish interpreter of such and such interpreting agency, and here's the certification number, and there's the phone number of the interpreting agency. And can you see that this use of detail and this fastidious attention to accurate detail, do you see how that could impress the reader of your report with you as a meticulous and fastidious evaluator? Can you see that? Next, another sample text, not the subject of today's discussion, but something of which you should be aware. You should be aware of these two labor codes, and this labor code and this code of regulation here. And it says, prior to the evaluation, I provided Mrs. Jones with a copy of the complete text of Labor Code 4623.3 E through H and California Code of Regulation 40, which is the disclosure requirements, which you should be familiar with. I gave her the opportunity to ask questions. I answered all of her questions prior to proceeding with the evaluation. And now here, this is the section that deals with Labor Code 4628 again. It says, I conducted every part of the evaluation personally, and face-to-face requirements were met in compliance with Labor Code 139.2 and 5307. Tell us, total face-to-face time with Mrs. Jones was 85 minutes. Now here is where our disclosure of the name and services provided by other persons is installed within the body of our report. We say, Office Assistant Sally Smith excerpted the review of records. I then made additional inquiries as necessary and appropriate to identify and determine the relevant medical issues. So that complies with 4628B, or 4628C, I'm sorry. Historian Alex Ortiz obtained the initial outline of Mrs. Smith's history. I then made additional inquiries as necessary and appropriate to identify and determine the relevant issues. And then finally, you could let us know, and this is just a sample text, let us know what is your billing code and what level of service this evaluation qualifies for. So in this way, this is just some sample text that you can show to the parties that you're aware of the requirements of Labor Code 4628 and that you comply with those requirements. Okay? So that's a good introduction as to how to begin the initial sections of your report. Let's now turn our attention to the review of records section of our report, which is recently receiving increased interest by all parties, especially due to the new fee schedule, which provides for $3 per page per record per medical record review. Okay, so let's talk now about your review of records. Okay, so let's talk about the review of records, and let me share with you some ideas as to how you can present the review of records within the body of your report to demonstrate to the reader of your report that you know about the review of records, that you know the language of the law that describes what constitutes a review of records, and that you know that you're to be paid and that you're to be appropriately paid for the exact page count of medical records that you're provided. So let me share with you some ideas how to exactly accomplish those objectives. So first, under CCR 9793, you should read the entirety of CCR 9793. This section of the Code of Regulations gives us the definitions of various terms used in the medical legal evaluation. It tells us what constitutes a contested claim, tells us what a claims administrator is, tells us what a medical legal report is. And here in section N, it gives us the definition of the review of records. So it tells us that the review of records means the review by a physician of documents sent to the physician in connection with a medical legal evaluation or request for a report. So a review of records means our review of documents. So then the next question is then, what constitutes documents? Well, it tells us the documents may consist of medical records, legal transcripts, medical test results, and or other relevant documents. Any documents that are sent to the physician qualify as documents which qualify as a review of document reviewed under this definition of the record review. For purposes of record review, a page of documents, documents are further classified and categorized and charged by pages. So here it tells us that a page is defined as an 8.5 by 11 single-sided document, chart, or paper, whether in physical or electronic form. Okay, physical or electronic form. And more, I don't know about you, but more and more we're demanding that our records be sent to us only in electronic form, but can include physical or electronic form, and multiple condensed pages or documents displayed on a single page shall be charged as separate pages. So we now know what a record review is, we now know what constitutes documents, and now we know what constitutes a page of documents of record review. Let's go on to further sections here under section N and talk about the rules involved with this particular review of records and how you as a qualified medical evaluator can comply with these rules. Now the next sections of 9793N tell us some of the rules that must be complied with by all parties with regards to the review of records. This is very, very important for us as qualified medical evaluators to understand. It tells us that any document sent to the physician for record review must be accompanied by a declaration under penalty of perjury that the provider of the documents has complied with the provisions of Labor Code section 4062.3 before providing the documents to the physician. Now this is of no concern to us as qualified medical evaluators This simply has to do with ex-parte communication and making sure the parties making sure that the other parties do not send medical records to the Qualified Medical Evaluator without also providing those documents to any opposing party. Okay, so this is not the concern of us, but the next section starts to become of concern to us. It says the declaration must also contain an attestation as to the total page count of the documents provided. A physician may not bill for review of documents that are not provided with this accompanying required declaration from the document provider. So for you as a qualified medical evaluator, when is it most important that you assure, and confirm that you receive this attestation? Of course, it's most important to you as a qualified medical evaluator when your page count exceeds the minimum count and when your page count starts to include billable pages. So how important is the attestation for an initial evaluation when there's only 100 pages of medical records, right? We don't get to bill for medical records until we have beyond 200 pages. So how important is an attestation when there's only 100 pages? You might not be so motivated to pursue an attestation when the page count of medical records is below the minimum, or I should say is below the maximum. Maximum for an initial evaluation is 200 pages. Beyond that, we are allowed to bill for additional pages. But certainly if you have more than 200 pages for an initial evaluation, you're going to want to track down the attestation and confirm that you get the attestation and that you include that attestation with your report when you submit your report. For a supplemental report, if you have beyond 50 pages of records sent to you, you're going to want to track down that attestation. For a follow-up face-to-face evaluation, you're going to want to track down that attestation if you're sent more than 200 pages of medical records. Okay? So you want to become a maverick and a hawk on tracking the number of pages that are sent to you for your evaluation. Now next is the section of 9793 that's the savior for us as qualified medical evaluators. And this section relates specifically to us and to our obligation to perform a review of records. It tells us that any documents or records that are sent to the physician without the required declaration and attestation shall not be considered available to the physician or received by the physician for purposes of any regulatory or statutory duty of the physician regarding records and report writing. So that's a lot of words, and that seems to be twisted legal language. But my interpretation of the language of this section of 9793 is that without the required declaration and attestation, those are records that we're not obligated to review. We're not obligated to review medical records when those records are not accompanied by a declaration and attestation. So as we said on the prior slide, when your medical record page count exceeds 200 for an initial evaluation, of course you're going to track down the required attestation and declaration from the claims administrator or the defense attorney or whoever is sending you those records. You're going to want to track that down if it's not already sent to you with those records. Now, for 199 pages of medical records, in other words, a count of pages for which you're not going to be submitting additional billing, if those medical records are not accompanied by a declaration and attestation, by the language of the law under 9793, those records are not available because they were not received. They were not considered to be available, and they are not considered to have been received by the physician. So those are records that I'm encouraging you to not review. If you're not sent the required declaration or attestation with those records, you're not required to review those records. And the opinions and conclusions of your reporting do not have to be based on medical records that you did not receive. Okay? So this is quite a bit about the review of records section of your report. Let me show you how you can fashion this within this particular section of your report so that you comply with all these requirements of CCR 9793. Okay, and here is the review of records section of the report. Okay, I'm sorry. Here's the review of records section of the report. And this is just some sample language. You can fashion this language however you want, but it's important that we demonstrate our compliance with both 4628 and CCR 9793. So it might look something like this within the body of your report. Here's your required statement. It says, I, John Smith, MD, QME, declare under penalty of perjury that, pursuant to Labor Code Section 4628 and Title 8 CCR 9793, I reviewed X number of pages of 8.5 by 11 single-sided documents, charter paper, whether in physical or electronic form, records in connection with my examination of Mrs. Smith. I received the following documents. From the applicant attorney, I received 100 pages. From the defense attorney, I received 110 pages. From the claims administrator, I received 0 pages. Total pages is 210 pages. Attached to this report are the declaration and attestations that I received from both parties. And your attestations from the two parties should total 210 pages. Should be exactly the number that you described related or given to you from the applicant attorney here. Should include an attestation with exactly this number of pages from the defense attorney. You provide us with your total pages. It's the 10 pages that then become excess pages that are subject to your $3 per page per document reviewed. And this is how you begin and introduce the review of records section of your report. You would then go on to tell us about your review of records and all the records that you reviewed. I suggest, for purposes of clarity, neatness, and chronologic order, that you put your review of records in a table and list those records in chronologic order, the way that the events occurred in actual real time. And here include every single document that you reviewed in connection with the report, including your own questionnaires that you might use in your evaluation, any symptom questionnaires or outcome assessments that you may use as a part of your evaluation, any diagnostic studies that you review as part of the report. Those would also be listed here under the review of records section of your report. And by incorporating the review of records section like this into the body of your report, it presents your review of records in such a way that it demonstrates to the parties that you comply with all of the requirements in both 4628 and in CCR 9793, and impresses the reader of the report with your meticulous and fastidious attention to detail. Okay? So that discussion has to deal with some of the mechanics and some of the nuts and bolts of our reports. Let's shift gears now a little bit and let me share with you some ideas as to how you can satisfy the parties that your report qualifies as a high quality report, meaning that your report actually has the capacity to resolve the disputed issues. Now, when it comes to the content and quality of your report, two of the codes of regulation that determine and dictate what needs to be included in your report are CCR 35.5 and 41C Section 5. So let's review these very quickly. And the first part of CCR 35.5 Section B contains some reiteration of what was told to us and what was required under CCR 4628, the first code that we reviewed in today's discussion. So let's just go over that quickly. It says each reporting evaluator shall state in the body of the comprehensive medical legal report the date, we already talked about that the examination was completed and the street address at which the examination was performed. So that's duplicative with the language of 4628. Now here it says if the evaluator signs the report on any date other than the date the examination was completed, which happens all the time, right? Which happens almost in every single case. Unless you're the type of evaluator who completes your evaluations on the same day that the evaluation was conducted. If you complete your report on the same day, then this won't apply to you. But for 99.99999% of the rest of us who don't complete the report on the same day, it states that the evaluator shall enter the date the report is signed next to or near the signature on the report. So this is very simple to comply with. Next to your signature line at the end of the report, put a line for the date of which you're signing the report. And certainly the date on which you sign the report should be no greater than 30 days after the date of the evaluation. Okay? So that's very simple and that's not a big deal. Let's see what the next sections of 35.5 and 41.5 have to say about the content of our report and about the capacity of our report to actually resolve disputed issues. Okay, so now we're getting into the content of our report as required under CCR 35.5 and 41C Section 5. And this is where you can really make great strides in separating your report from the mass of other low quality and terrible reports. If you'll simply adopt this one single concept into your report writing with your next evaluation, it will immeasurably improve the usefulness of your report to the people who use the report to resolve the disputed issues, which are the parties. The parties are the persons that use your report. So let's dissect Section C1 of CCR 35.5. It tells us that the evaluator shall address all contested medical issues arising from all injuries that are reported on one or more claim forms. An injured employee could have multiple claim forms, correct? So we're required to address all those issues that are reported on one or more claim forms prior to the date of the employee's appointment with the medical evaluator. So we certainly can't address issues that are on claim forms after the date of our evaluation. Okay, so that makes sense that the date should be prior. The date of the claim form should be prior to the date of the evaluation. And we're to address all issues that are within our scope of practice and areas of clinical competence. So this is very interesting. So now let me ask you, where does the qualified medical evaluator obtain this information, the information about the contested issues? Where does the qualified medical evaluator obtain the information about the injuries that are reported on the claim forms? Do we get claim forms in every single case? We don't, do we? Do we know the issues? We don't know the issues. So we, as qualified medical evaluators, rely on the parties to provide us with the contested medical issues, to provide us with the context of the evaluation so that we, as qualified medical evaluators, can actually address those issues. So this is an area where we rely on the other parties to give us the necessary information so that we can do a good job. Absent the necessary information, it becomes impossible for us to do a good job. So the way that the parties provide us this information is through their cover letters. This is the form of communication that the parties use to communicate with us as qualified medical evaluators. And it's the only method of communication that's allowed within this system is through the use of cover letters. So the next section tells us what our responsibility is with regards to the cover letters. It tells us that the reporting evaluator shall attempt to address each question raised by each party in the issue cover letter that is sent to the evaluator. So this can become quite a task. This can become quite a project to address each question in each cover letter raised by each party. So imagine that you get two cover letters, one from the applicant attorney and one from the defense attorney, and each of those cover letters have a dozen questions, 15 questions, 20 questions. It's our obligation under this section of the law, 35.5, to answer each and every question that's contained in the cover letter. And this makes sense. And this is how our reports have to be written to service the reader of our reports. In other words, we write our reports for other persons. It's other persons that use our reports, and other persons can only use our reports when those persons get the questions, the answers to questions related to contested medical issues. So those contested medical issues are elaborated to us in the cover letters. Our obligation under this section of the law is to answer those questions. Now, this section of the law is reiterated in another section, which is 41 section C, section 5. So let's take a quick look at that. Section 41.5 is very similar to 35.5, and it tells us that the Qualified Medical Evaluator is required to present a report that addresses all relevant and contested medical issues as presented on one or more claim forms. And again, we receive that information from the parties through their cover letters. So we must address all of the questions that are given to us in the cover letters. Additionally, now under this particular section, the section tells us that the report is required to be rateable by the Disability Evaluation Unit in those cases where the evaluation involves a permanent impairment opinion. So it must be rateable. So therefore, it must be consistent with the AMA guides, and the Qualified Medical Evaluator must be familiar with rating permanent impairments and all the issues related to rating permanent impairment, and it complies with all relevant guidelines of the administrative director. So how do you do this? How do you do this within the body of your report? This would seem to be a very complex task, but I want to show you a simple formatting outline that you can use in your very next report that will allow you and will help you in exactly answering the questions that are raised by the parties in their issue cover letters. So this is how this would look in the discussion section of your report. And you begin the discussion section of your report by demonstrating to the reader that you're aware of and that you intend to comply with CCR 35.5 C1. And you tell us here that according to this regulation, the evaluator shall address all contested medical issues and exactly the language of this regulation. So you reiterate the language of this regulation. And then you tell us, for this evaluation, I received cover letters from both Defense Attorney Jones and from Applicant Attorney Thomas. Or tell us the specific circumstance. For example, for this evaluation, I received a cover letter from Defense Attorney Jones, but I did not receive a cover letter from Applicant Attorney Thomas. Or for this evaluation, I did not receive any cover letters from either Attorney Jones or Attorney Thomas. And here tell us the situation of the cover letters that you received, and then tell us that here below I address each of the questions raised in each of the cover letters that I received. Now, I've completed here an example of the causation section of this report, and this is just an example as to how you might fashion the causation section of your own report. So here you list the questions from the applicant attorney's cover letter. You list the questions. Now, I have it listed here as question number 1, question number 2, question number 3, but you would not do that in your report. You would do it just like this. you would say, please provide your diagnosis, right, and list exactly the question. But for purposes of illustration and for teaching of this section, I have it listed here by the question number, okay? But you would omit these words from your report, question 1, question 2, question 3. So this is just an example. Question number 1 says, please provide your diagnosis of Mrs. Smith's condition of cervical spine, right shoulder, left knee, and hernia, and address work relatedness for each of these diagnoses. Now you'll notice that this is a multiple part question. He asked first, question number 1 is, what's the diagnosis of all these body part conditions? And then once the diagnoses are established, he says, then would you please, in the second part of the question, address work relatedness. Please address. So you might say the two verbs are provide, and the second verb is address. Okay? So this is a two-part question. First part is provide your diagnosis. Second part of the question is address work relatedness. So you might answer that as follows within the body of your report. Diagnoses. Okay? Diagnoses. My diagnoses of Mrs. Smith's condition and the work relatedness of those follows. And see here, this is how you're going to address both components of the question. Component number 1 is the diagnosis. Component number 2 is the work relatedness for each of the body parts that are raised in the question. So then you would simply provide the diagnosis here and then give us your explanation here as to the work relatedness of that cervical spine diagnosis to the workplace duties described by Mrs. Smith. So this would be how you would answer question number 1. Question number 2, are your medical findings consistent with the mechanism of injury alleged by Mrs. Smith? This is a type of question that we frequently see in our cover letters. So you would address that as follows. And notice how I've given these a topic headline. This is a concept known as topic headline formatting. The headline here is diagnoses. He says, please provide your diagnosis. So the heading becomes diagnoses. Second question, are your medical findings consistent? So the topic heading becomes consistency of medical findings. This is a concept entitled topic headline formatting. This is a procedure used by all publications, newspapers, magazines. They all start with a headline, and this is the headline of the topic that you're discussing. So here you would address the consistency of the findings. In my opinion, the medical findings of cervical spine, right shoulder, left knee, hernia either are or are not consistent with the mechanism of injury described by Mrs. Smith. Reasons for this conclusion, and then here's how you make your opinion on this substantial. You give us the reasons for your conclusion. And so you would give us the reasons supporting consistency, or reasons for inconsistency of the cervical spine. And repeat that for each of the body parts in question. Question number 3, if you find a specific injury and a cumulative trauma injury applicable, please indicate why and support your reasoning. So that's really a 3-part question. First of all, is there a specific injury? Is there a cumulative trauma injury? Why is there a specific? Why is there a cumulative trauma? And what are your findings and reasons to support a specific injury, a cumulative trauma injury, or both types of injuries? So this is a multi-part, very in-depth question, and you might answer that as follows. Here's the topic headline, specific and or cumulative trauma injury, colon. In my opinion, the symptoms that Mrs. Smith reports with the cervical spine, the right shoulder, the left knee, and hernia are due to both a specific incident of injury on 2/2/19 as well as a period of cumulative trauma, 1/119 through 1/120. Reasons for this conclusion include, and then give us the reasons as to why. He says, support your findings and reason. So here you support it with your reasons for this conclusion, and then give us the reasons why you opine for a specific injury and the reasons why you opine for a cumulative trauma injury. And doctors, in this way, you can satisfy the parties that you're resolving the disputed issue by answering the specific questions that they address to you. Anything short of an answer like this lowers the quality of your report and reduces the ability of your report to resolve the disputed issue. If your report is unable to resolve the disputed issue, that simply introduces delays into the system and increases costs into the system, and can also lead you into a denial of your reappointment, which we'll talk about in just a moment. But let's conclude this discussion by stating that that's just one set of questions from the applicant attorney. You would then repeat the same process for the questions from the other attorney. Question number 1, 2, 3, headline 1, 2, 3, answer, answer, answer. Same format under permanent and stationary. Same format under permanent impairment. List all the questions and then answer all the questions in each cover letter. And in this way, you can write the report in the way that the user and reader of the report needs to have the language fashioned such that they can use it to resolve the disputed issue. And if you can do these things in your report, if you can actually resolve the disputed issues, you can enjoy a long, happy, and profitable career as a qualified medical evaluator. But if you're not, and if your reports come under scrutiny of the judges as insufficient reports that fail to meet minimum standards, your reappointment as a qualified medical evaluator can come into jeopardy. And that's provided for by law under Labor Code 139.2D, which tells us that the QME, upon request, shall be reappointed if he or she meets the qualifications of subdivision V and meets all of the following criteria. And here's one of the criteria described under Section 2. It says, has not had more than 5 of his or her evaluations that were considered by a workers' compensation law judge at a hearing rejected by the judge or the appeals board during the most recent 2-year period during which the physician served as a qualified medical evaluator. So if your reports, and I shared with you how the judges are going to become more required by the DWC to identify deficient reports, and I shared with you how the judges are eliciting and soliciting help from both the applicant attorney and the defense attorney in identifying substandard reports, more and more reports are going to come under greater and greater scrutiny by the parties, and particularly by the Division of Workers' Compensation, and that can adversely affect your reappointment following your 2-year term. So I'm encouraging you to take today's considerations and immediately implement them into your very next evaluation. So doctors, I hope this helps you. You know, writing a high-quality report that the parties can use to resolve disputed issues is actually not all that difficult. And the recipe for writing a high-quality report is found within these labor codes and codes of regulation. You know, sometimes we feel that the QME regulations have as their purpose to make our lives miserable and to punish us, but exactly the opposite is actually the case. The purpose of these labor codes that I shared with you today and the codes of regulation that I shared with you today, and actually all of the QME regulations have as their purpose to improve the system that we work in, to improve our final work product. So if we simply follow these codes and these regulations to a T, our reports can improve immeasurably. And as you gain a reputation as a competent and quality evaluator who quickly and accurately resolves disputed issues without delay, well, you're going to see your practice and your influence as a qualified medical evaluator expand greatly and very profitably as well. So I want to thank you for taking the time to join me on today's discussion. I want to thank you for your commitment to excellence as a qualified medical evaluator, and I look forward to being with you on our very next discussion. For now, this is Dr. Perry Carpenter wishing you best of success in your career as a qualified medical evaluator.